Amongst the greatest political issues which divide our nation on partisan lines today lies perhaps the most impassioned and hotly debated of subjects, the right to an abortion. The right to an abortion was affirmed and first tackled by the Supreme Court case Roe v. Wade, and that's what I'm going to be talking about today. I want to be clear. In this presentation, I will not be talking about whether abortion is an immoral act, the ethics of abortion, whether there should be legislation for or against it. In this presentation, I'm going to be talking about the arguments for Roe v. Wade and look at the flaws in their arguments. And I'll hopefully be able to convince you that the January of 1973 decision on Roe v. Wade was a poorly decided case and that it should be overturned by the United States Supreme Court. So let's first look at the holding of the Supreme Court case. The holding is, quote, "The due process clause of the 14th Amendment to the United States Constitution provides a fundamental right to privacy that protects a pregnant woman's liberty to choose whether or not to have an abortion. The Texas law, which is being fought against by Jane Roe of Roe v. Wade, that made it criminal to help a woman get an abortion, was deemed an abridgment of constitutional law." So let's look at the arguments being made here, beginning with the right to privacy. The right to privacy was made because of the connection of the 14th Amendment's, quote, "right of the people to be secure in their houses, papers, and effects against unreasonable searches and seizures." However, this has no logical connection to abortion. Being protected from a government agent's intruding on your privacy to your own effects does not mean that you have the right to personally make the decision to go and get an abortion. There is no logical connection. Justice Blackmun attempts to establish another connection with the right to contraceptives that was established in Griswold v. Connecticut. And even though they may be similar, they are fundamentally different in that an access to an abortion is not an investigation to a couple's bedroom, and it is personnel rather than spouses that are being considered in the case. With the logic of the Roe v. Wade decision, any sort of level of privacy would be allowed, considering if it's out of the public eye. This would mean that things like child pornography, drug abuse, animal abuse, and even child abuse would be permitted, since it's all done in the privacy of one's home. The Supreme Court's decision here was done out of an act of desire to put what they willed the Constitution to say, not what it actually said, and it's a poor practice of constitutional law. Another problem with the Roe v. Wade decision is something that Justice Antonin Scalia called substantive due process, which was the ideology of the Supreme Court at the time. Substantive due process is, quote, the idea that some liberties are so important that no process will be sufficient to take them away. But as Scalia points out, the due process clause in the Fifth Amendment says that all the rights of life, liberty, and property can be taken away, just not without due process. What is being said here in the Roe v. Wade decision is that there is no process that a state can decide is appropriate to take away the right to an abortion in the first trimester. That is not the job of the United States Supreme Court. It is not their job to decide what states can and cannot put under legislative scrutiny. Their job is to determine what laws that are currently on the books are not constitutional, as per their ability of judicial review. According to Justice Antonin Scalia, quote, "The court has liberated itself from the text of the Constitution, from the text and even from the traditions of the American people. Again, there is no constitutional basis for the majority opinion in Roe v. Wade." Another problem with the Roe v. Wade decision is the idea of Justice Blackmun's, quote, "potential life of the fetus." Now, their argument is that if it is not under an actual life, then it's not deserving of the rights granted under the Constitution. However, this is flawed logic, as there are many animals in the Animal Protections Act, Environmental Protection Agency, and legislation of that sort that allows protection of animals from certain practices of humans, from harm. Even turtles' eggs, which are essentially the fetus, are protected in these laws. So states have the right to legislate when it comes to animals, so they should absolutely have the right to legislate when it comes to people. But even if that were true, the absolute scientific consensus is that life begins at conception. Steve Jacobs from the University of Chicago did a poll study that got 5,577 results back from biologists across the nation. 96% of them agreed that life begins at conception, regardless of their leanings as to being either pro-life or pro-choice. By the time of conception, they have their own unique DNA, skin, nose, eyes, vocal cords, and other things that make them a completely unique individual. They are entitled to life. They are entitled to the right to life, unless it is taken away through the due process of the law. And in an abortion, they are not granted that due process. Finally, there is the issue of the large amount of expert legal opinion that goes against the Roe v. Wade decision. This includes 6 former Chief Justices: White, Rehnquist, Scalia, Thomas, Kennedy, and O'Connor. Harvard's own Lawrence Tribe, who supports Roe v. Wade on other grounds, but did not support the Roe v. Wade decision on the legal terms. Yale Law School professor John Hart Ely, who stated, "It is a bad case," or Roe v. Wade is bad law because it is bad constitutional law, or rather because it is not constitutional law and gives almost no sense of an obligation to be. Edward Lazarus, who was the law clerk to Roe's author of Justice Blackmun, also stated that, quote, "As a matter of constitutional interpretation and judicial method, Roe borders on the indefensible. The problem, I believe, is that little constitutional connection to the right that is purportedly interpreted. The constitutional right of privacy broad enough to include abortion has no meaningful foundation in constitutional text, history, or procedure," end quote. The logic of Roe v. Wade does not constitute a sound legal opinion. It is overreaching in its purpose and is predicated on outdated science. Many scholars of today would agree that the Supreme Court case of Roe v. Wade was poorly decided. So with this information, if you were not convinced before, I hope that you are now convinced that this is not a partisan issue. Regardless of your thoughts on the ethics of abortion, whether it should or should not be allowed, it should be clear that Roe v. Wade is a poor excuse for constitutional law and should be overturned based on the flaws of its own constitutional legal grounds. Thank you.